sort of a hornet's nest, right? As you mentioned quite correctly and succinctly, like recital 106 of the Act basically is meant to supplement the interpretation of this copyright policies obligation. And it says that even if the relevant text and data mining activity takes place outside the EU, the example is always a jurisdiction that in theory would have laxer requirements, be it, although probably not anymore the US, but Japan is an example, Israel would be an example, and depending on how things pan out in the UK, could be an example. The idea of this recital is that, okay, even if that activity takes place outside, the rules of the AA Act apply. Now, obviously, the logic is understandable, right? The Act is a sort of a product safety approach. And the idea is, and it's stated in the recital, that we don't want the provider to gain a competitive advantage in the EU by applying lower copyright standards than those provided in the EU. So it's basically a prevention or avoidance of regulatory arbitrage, and that is very consistent with this product safety logic. And some authors call this a market entry requirement. Others consider it like with some level of creative interpretation that this basically allows EU copyright directive rules like those on TDM to acquire direct effect vis-a-vis private legal entities outside the EU. I'm a little bit more doubtful. And the reason why I'm more doubtful is that if you depart from the principle that copyright is territoriality, there is something like the rule of infringement of lex loci protectionis, which is the law of the country of which protection is claimed. Without being too technical, this basically means that you have to take into account the law where the activity takes place to determine what is the relevant copyright rule.